Hello, welcome students, welcome to the PYQ series of SRIRAM's IAS, and we are bringing you at 4 o'clock every day 10 questions or even more questions from different themes of the previous years, which will help you in your upcoming prelims examination of 2025. So today is the day of polity. Let us see some previous year questions on the topic of historical underpinnings and the salient features of the Constitution. Okay, so yeah, my pen is working and let's begin the discussion. So the first question here relates with the topic of Government of India Act 1919. Too many questions have been asked on Government of India Act 1919. This question is of 2015, and let's see what this question is all about. So the Government of India Act 1919 clearly defined, these were very important act leading towards the partition of the country and to the independence of the country. The 1919 Act, the 1935 Act, the Independence of India Act 1947, all these are very important acts. Even the Council Act of 1909 is very important. So everybody knows about diarchy, which was introduced in this act in the provinces, and then in the 1935 Act, diarchy was to be implemented at the central level, and the provincial level has to get autonomy, which it got. And in 1937, several ministries of the Congress were established, giving a little bit of autonomy to Indians to work for Indians. It was very important. And the meaning of diarchy we are going to understand in question number 2, but let us first answer what is question number 1. Let us see this. So this particular act of 1919 clearly defines which among them. So of course we shall start with A, the separation of power between judiciary and legislature. Was this the answer? I'll go with B. Why? Because if you read it carefully, the jurisdiction of the central and the provincial government, these were separated and delineated in the Act of 1919. This is very important for you to understand. Those lists, list where there's provincial list, the federal list, provincial list, and the concurrent list. These lists were made in the Act of 1935, but the delineation and the separation of the jurisdictions of central and provincial governments happened in 1919 Act. So 1935 Act is a step forward. First the jurisdiction were separated, okay, and after that the lists were made in 1935 Act. Residuary power was also given to the Viceroy in the center in the 1935 Act. Okay, now if you see in the Indian Parliament, the residuary power is with the Parliament. Okay. In the independent India, the residuary power is with the Parliament. So option B is correct here. Let us read the option C also. The power of the Secretary of State for India and the Viceroy. The Secretary of State and Viceroy, this is an old thing. This does not come in 1919. So the clear-cut answer here is B. The jurisdiction of the central and the provincial governments were separated and delineated in the Act of 1919. Let us read question number 2, which is very important in the context of Indian history, the principle of diarchy. So Indians were always asking for autonomy. So Britishers have found out a way that if you want autonomy, you want to work on several subjects. We are going to give you several subjects, several items to make laws on, to legislate, to execute, to do whatever you want, but not the important ones. They didn't say it, but they did it. That they have divided the whole items into two, reserved and transferred. Reserved were the one which were very, very important, such as police, such as administration, criminal justice system, revenue, land revenue, and things like that. And transferred subjects such as irrigation, education, local government, all these were transferred so that Indians will feel satisfied and the British government is going to hold the majority of the power in India. So this system of diarchy was also introduced in 1919, and according to this question, we have to define what is diarchy. Diarchy is defined clearly in which of the one statement among these four. We have to see. Division of the central legislature into two houses. Now, when you have two houses, that's called bicameralism. What is bicameralism? Having two houses, such as Lok Sabha and Raj Sabha, such as legislative assemblies of the state and the legislative councils. We do not have legislative councils in India in all the states except 6. But we do have a bicameral feature at the central level. So it has nothing to do with diarchy. Having two divisions, two houses at the center, it is bicameralism. It has nothing to do with diarchy. Introduction of the double government, central and the state government. This is federalism. You have two layers of government. Same set of people governed by two, center and the state. So again, this is not the option. Having two set of rulers, one in London and another in Delhi. This was happening from a long time. It was the parliament there, the Secretary of State, the British Parliament and the King through the Secretary of State, who was a cabinet minister in the Council of Minister of the government established in London. And the Secretary of State, directly under him was the Viceroy or the Governor General of India, who used to govern India. But this was also not diarchy, as we have understood that diarchy was separation of item, reserved and the transferred one. So D becomes our option here. Let's see what is written. Division of the subjects delegated to the provinces into two categories. Into two categories. Which were the categories? The reserved and the transferred category. D is our answer. D is the correct answer here. Coming to question number 3. In the Government of India Act 1919, again another question on Government of India Act 1919, very important act. So see, this is how the previous year question helps you. It tells you from which segment the questions are going to come, from which topic more and more questions are going to come. You all study polity, but inside that polity there are many topics which are more important than the other ones. You have to understand that, and you can only understand that from the previous year question. Now see, in line 3 questions has come from 1919 Act. This is 2022 year, this is the year 2017, and this is the year 2015. They are repeating the questions from 1919 Act. Government of India Act 1919, the functions of the provincial government were divided into reserved and transferred subjects. This is what is called diarchy, isn't it? We have just now seen. Okay. Which of the following were treated as reserved subjects? So I have already told you, reserved subjects were the one which were important. They were kept in the hand of the British government, and transferred were the one which were given to the Indians to legislate upon. So among these 4, which one do you really think are the important one and were reserved? Administration of justice, of course, this is one of the most important thing. If you give this to Indians will send the Britishers to jail. Okay, this is very important. Local self-government, not important. Land revenue, very important. All the money which was, taken from the Indians was sent to Britain in some or the other manner. Police, again, how can they? The whole idea of not giving police to the Indians, because police, bureaucracy, military, these were the things which are holding the British Empire together. If you take out police, military and bureaucracy, what is left? 1500 Britishers here in India. They are of no use. Any day they could be crushed by millions of Indians. So, police, local self-government, this is not the land revenue, and administration of justice. So 1, 3 and 4 is the answer. C is the answer, 1, 3 and 4. The important topics were kept by the Britisher and the unimportant topics were transferred to the Indians. In the federation established by the Government of India Act 1935, now in 2018, we have seen in 2015, 17 and 22, question was asked on Government of India Act 1919. In between, in 2018, the question is asked on the Government of India Act 1935, a very important act again. Residuary powers were given to, we have discussed this thing, residuary power now in India is with the Parliament. Under Article 246, we have three important lists. Division of power, the central list, the state list and the concurrent list. Similarly, these lists were introduced in the 1935 Act. We have the federal list, the provincial list and the concurrent list, and any subject, any item which is falling outside this was called as the residuary matter. Now, in modern India, in the India after the commencement of the Constitution, the residuary power is with the Parliament, the highest authority when it comes to the policy making and law making. But at that time in 1935, according to the 1935 Act, this residuary power has to be given to whom? The Governor General. If you see this, he is the highest authority here among all the four. Federal legislature worked according to the Governor General, who worked according to the Secretary of State for India, who was a cabinet minister in the British government, which had a responsibility towards House of People of Britain. All these worked under the king or the queen, whatever be the case. I hope you understood. So B is our answer. The residuary power lied with the Governor General. Under which schedule of the Constitution of India can the transfer of tribal land to private parties for mining be declared null and void? So we know this is the 5th schedule, no other schedule. 3rd schedule says something else. Oaths, affirmations. 9th schedule, this is something under which if anything comes, there is no judicial review for that. But with the coming of the Keshwananda Bharti case in 1973, everything, every item which is put under the 9th schedule is also reviewed. 12th schedule is totally different, local self-government. But this is the 5th schedule where the tribal matter comes. Okay. And governor has been given an overarching power in this matter. Governor has too much power. Governor can also decide which act of the Parliament in which manner can be applied to these tribal areas, these scheduled areas. Okay. So this is number 5th schedule. Coming to the 6th question, which one of the following is not a feature of the Indian federalism? Again, see the basic salient feature of the Constitution, they come again and again. What is the union feature? Which among them are the federal feature? All these keeps coming every time you see previous year questions. These things are very, very important, and I think you should pay attention to these basic features of the Indian Constitution. Like federalism. Which among them are the features? There is an independent judiciary in India. It has nothing to do with federalism. Federalism simply means same set of people governed by 2 levels of government or 3 levels of government. For example, central government, state government and the local municipal or panchayat. Okay, same set of people. Jurisdiction may decrease. Central government have the jurisdiction over the whole India, state has jurisdiction over the state, and municipality or panchayat have the jurisdiction over those areas. But same set of people. That simply means if you are living in some panchayat area, you will be governed by your panchayat, you will be governed by your municipality, you will be governed by your state government, and you will be governed by the central government. Different level of government. This is called as federalism. So, independent judiciary, very good, but has nothing to do with federalism. Powers have been clearly divided between the center and the state. Feels like this? Is it? Okay, let's see. They are saying which among them is not the feature. Not the feature, very important. The federating units have been given unequal representation in the Rajya Sabha. Have been given unequal representation in the Rajya Sabha. Good enough. Let's see the fourth one. The result of an agreement among the federating units. Does India have, any kind of agreement? They are asking not about the features of federalism, but they are asking about the features of Indian federalism. Indian federalism. It is very important to understand in India, federation was created after the union was created. Simply means the union was created first. India is a country of indestructible union with destructible states. That simply means the power of the union government is far more than the power of the state government. Under Article 3, the central government had the power, or the parliament has the power to make the state, break the state, diminish the boundaries of the state, change the name of the state, reduce the area of the state, bifurcate the state into two, join two or more states together to make a single state. Anything can be done without the permission of the state governments. So simply we understand this, that the union government in India or the parliament in India has more power than the state government or than the state legislative assembly. Okay. And all of this system has nothing to do with an agreement. There was no agreement. India became independent, a central government was created, and then later on the states were created. In 1956, several more states were created. In 1965, several more states were created. The basis of creating state in 1956 was languages, linguistic states. Before that, there were like Madras, to huge state. Mysore was also a state. But later on, it became Tamil Nadu and then Andhra Pradesh, and they bifurcated on the basis of languages. Who was doing it? The central government. So there was nothing like agreement among the federating state. So if you search for the most appropriate option, you will come to this option number D, because it is not a feature of Indian federalism. To an extent, we can also say that having an independent judiciary is important in a federal government. Why? Because if there is an independent judiciary, the original jurisdiction of any dispute between the center and the state government or between two state governments lies with the Supreme Court. So in order to have a running and an efficient governing system, it is very important in a federal polity to have a Supreme Court, that too an independent Supreme Court, because the original jurisdiction of the disputes between the state of one federating unit with the other federating unit lies with the judiciary, lies with the Supreme Court. So in a way we can also say that A is the feature of federalism, B definitely is the feature of federalism, C definitely is the feature of federalism. But D, although a feature of federalism but not the feature of Indian federalism. So we will mark D as our option. It is not a feature of Indian federalism. It is a result of an agreement among the federating unit. There was no agreement, neither between the states and the center nor between two states. Hence, D is the option. Out of the following statement, choose the one that brings out the principle underlying the cabinet form of government. So this word cabinet was not used until the 44th Constitutional Amendment Act in 1978, where the word cabinet was used for the first time, that if an emergency under Article 352, the proclamation of emergency, if has to be imposed in India, written permission of the cabinet is needed. The President of India has to ask for the written permission, all the cabinet minister has to write down that yes, there is a chance of war, external aggression or armed rebellion in the country. These are the basis of proclamation of emergency. And such a situation has arisen, and for the protection of the country, for the protection of the polity, for the protection of governance and the people of India, it is important, and we give this in writing all the ministers of the cabinet, that the proclamation of emergency has to be imposed. So the cabinet was for the first time comes there. But in a parliamentary form of government, cabinet is a very important element. Even in the British Parliament you will see, in Indian Parliament you will see. So we have to see which one brings out the principle underlying the cabinet form of government. An arrangement for minimizing criticism against the government. No, it is wrong. There is no mechanism to minimize the criticism for government. This is a wrong statement. You don't even have to read it fully. A mechanism for speeding up the activities of the government whose responsibilities are increasing day by day. So, this is not, has nothing to do with cabinet form. Cabinet may help it, but it has nothing to do with the cabinet form. Mechanism of parliamentary democracy for ensuring collective responsibility of the government to the people. Yes, this can be our answer. The principle of collective responsibility, the Council of Ministers responsible to the Lok Sabha, is the feature of the parliamentary form of government in India. So C can be our answer, but do not mark it before we read the option D. A device for strengthening the hands of the head of the government. Head of the government means president in this matter. Head of the state. President is head of the state. Prime Minister is the head of the government. So what they are writing is a device for strengthening the hands of the Prime Minister, who hold over the people in a state, is in a state of decline. No. This cannot be a good answer to cabinet form of government or cabinet system in the parliamentary form of government. No. Answer is C. A mechanism of parliamentary democracy for ensuring collective responsibility of government. So Council of Ministers is there, the cabinet is chosen from those Council of Ministers. All of them are responsible to the Lok Sabha. That is the mechanism which is called as the collective responsibility mechanism, followed in the parliamentary form of government. A very strong form of government, if you see, where the executive is responsible to the legislature and is chosen from the legislature. Question number 8. The 9th schedule, we have already seen a box. If you put anything in this box, judicial review is not allowed. This was introduced in 1951. Also mentioned in an article which was inserted in the First Amendment Act in 1952. First Constitutional Amendment Act. This was inserted 31B, which talks about 9th schedule, that anything, it was giving a blanket of protection of land reforms done by the Indian government, so that the judiciary does not declare it null and void on the basis that it is infringing with the fundamental rights of the citizen. Since there was also Article 31 which gave property right to the people, and because strong property rights were given and were made the fundamental rights, government cannot do developmental work related with the management of urbanization, work related with infrastructure development, work related with land reforms. Nothing can be done because of the strong property rights, and that is the reason why by the First Amendment 31A, 31B, all these schedules were implemented, and through 31B for the first Constitutional Amendment Act in 1931, 9th schedule was introduced. Now this happened in the Prime Ministership of course, Jawaharlal Nehru. It is the case of 1951. Coming to question number 9. Consider the following statements. The Parliament of India can place a particular law in the 9th schedule of the Constitution of India. Yes, Parliament has the power. Parliament has the power to place a particular law in the 9th schedule. True. The validity of the law passed in the 9th schedule cannot be examined by any court, and no judgment can be made on it. No, it can be examined. So, the basic idea for establishment of 9th schedule was to save the law, the policy or the legislation from judicial interference or judicial review. But still judiciary can, check those law on several bases. This have happened after the judgment of Keshwananda Bharati. In 1973, this judgment came and it resulted in judicial sort of interference in 9th schedule, that judiciary can actually look after every law which the executive or the parliament is putting in 9th schedule. Judicial review of 9th schedule is allowed after the Keshwananda Bharati judgment. Before that, it was not allowed. Before that, Parliament has the power to make any law and put it under 9th schedule. Okay, but that is no more a power in the hand of Parliament. Judicial review is now allowed after the Keshwananda Bharati case of every act which you put under 9th schedule. In this way, the check and balances between the different organs of the government is maintained. It's a very important judgment. So, option 1 is correct, but 2 is not correct. So, only 1 is the option. The last question. Who was the provincial president of the Constituent Assembly before Dr. Rajendra Prasad took over? So we all know Dr. Rajendra Prasad was the president of the Constituent Assembly, and this particular Constituent Assembly, which was making the, which was drafting the Constitution of India, started in 1946 and it continued till 1950. The Constituent Assembly drafted the Constitution of India, made the Constitution of India, and finally adopted, enacted and passed it, and it was enforced on 26th of January 1950. The president of this Constituent Assembly was Dr. Rajendra Prasad. But just before he became the president, who was pro tem president, or shall we say provincial president, and the name of Dr. Sachidanand Sinha comes here. He was the provincial president. C. Rajgopalachari, a very well-known figure, the last Governor General of India and the first Indian Governor General of India, but he was not the provincial president. Dr. B.R. Ambedkar, the chairman of the drafting committee of the Constitution. T.T. Krishnamachari, he was also a well-known figure, but not the provincial president. So it was Dr. Sachidanand Sinha. So thank you very much for joining me in this PYQ session. Next topic, next subject will come tomorrow. We will meet you every day at 4 o'clock for solving this previous year questions, and this series will go on till your prelims examination. This is just to tell you the role and the importance of previous year questions in your preparation. I hope you are preparing well. I hope you pass this examination with flying colors. Thank you very much. Have a nice day. Jai Hind.